Thanks, everybody. And I want to thank NACM for scheduling this conference during a heat wave in Minnesota, at least compared to last week. I was checking the weather reports carefully before we came out. So we're going to talk today about the Bipartisan Safer Communities Act. How many people know something about it already or have? Okay, just a couple. Good. So here's what we want to cover today, sort of our outline. What is the Bipartisan Safer Communities Act? We'll just do a real quick briefing on what it is. And feel free to ask questions along the way. We'd love to have some dialogue. We talk about funding that's available to the courts, because there are a couple of interesting funds that specifically talk about state courts within the bill. How do you apply? And what are some of the challenges and opportunities in this particular funding? And we'll have, as I said, time for questions and answers. So, the Bipartisan Safer Communities Act is the first major federal firearms legislation in decades. It was hastily passed after, as you know, some high publicity events last year, and it was passed very quickly and without a lot of hearings or debates. So I would say there's a lot of uncertainties in the bill language going forward that are going to be worked out as it's implemented. But in general, it contains funding for mental health services in various categories in various departments. So that was part of the debate of and kind of the trade-off, frankly, for some of the firearms restrictions were funds for mental health services, which is not necessarily a bad thing. It does expand some restrictions on the sales of firearms and adds persons in a dating relationship to the category of domestic violence perpetrators who are prevented from purchasing guns. This was known as closing the boyfriend loophole in the media. But especially pertinent to state courts are the two funding streams that I mentioned. Supports improvements, and by supports I mean funds, in certain juvenile adjudication records, both juvenile justice and juvenile mental health records, to the NICS system, the National Instant Criminal Background Check System. And we're going to talk a little bit more about the mechanics about how the NICS system operates and how it could be affected by the law. And it provides funding through the Burn-JAG system. How many people know about Burn-JAG already? The Burn-JAG is the major criminal justice federal funding to the states and local governments. It's been around for many decades, and we'll talk more about sort of the mechanics of how it works, but the Bipartisan Safer Communities Act amended the Burn-JAG statute and provides a new fund for state crisis intervention programs, and we'll talk about both these things in a little more detail. So unlike many federal statutes, and when I said this went through Congress very quickly, as you may know, we're used to statutes that authorize funding, and then the funding is actually appropriated in the budget process. And this was a rare instance where funding was appropriated at the time it was that the law was passed. So it was instantly appropriated and began in fiscal year 2022, even though that year was half over by then. So I'm going to, and it's a rare bill, really, to recognize the role of state courts and the importance of state courts. And we'll talk more about that and get into it as we talk about the funding in particular. But I'm going to turn to Terry now and talk about the NICS process.
Thanks, Chris. So how many of you are familiar with NICS? A couple people. I don't have my hand up because I am just brand new to this. As someone who has worked in juvenile and family courts for 20 some years, I hadn't thought about NICS that much. And when the legislation came out, a lot of people in the juvenile justice community and advocacy community were confused and a little worried because, we've spent a lot of our energy over the past 2 decades talking about the importance of confidentiality in juvenile records. And so there was some concern about what this means. So we've spent some time really digging through what this means for juvenile records and what's different in the Act. So I just want to kind of walk through what way oversimplified version of NICS that if anyone from Search was here, they would be maybe offended. But in your app, there's great handouts actually from the Search group who has document, and from the FBI who is talking about how they look to see NICS working under the Bipartisan Safer Communities Act. So my 9,000 feet overview, you can get a much more detailed description of it in your app. But essentially, somebody wants to purchase a gun, they go hopefully to a licensed firearm dealer to do that. The seller then has to contact NICS and ask and find out if that person has any disqualifying offenses. And once the seller contacts NICS, NICS has 3 days to do a background check. Now there is a nuance here we'll talk about in a second, where in some states, the FBI is in charge of doing this background check for all of those, all of the potential licenses. And then other states are what are called POC, or point of contact states, and they hold the data within themselves. They don't necessarily have to go to the FBI to get that information. And typically there's a 3-day span of time for NICS to be able to identify whether there is a disqualifying offense for that individual. And if no disqualifying offense is identified within 3 days, that individual does receive or is able to purchase a gun or get the permit for a gun. And you may recall in the Virginia Tech shooting, one of the issues that came up was that the shooter from Virginia Tech went through this NICS process. They did not identify a disqualifying offense, but that individual did have a mental health adjudication that should have disqualified them from purchasing a firearm. And so because that record was not found within 3 days, they were able to pursue that firearm. So that is one of the reasons why there's been a big push from the federal government and from FBI to make sure that we have complete records in NICS systems, whether they are at the state level or federal. And what the Bipartisan Safer Community Act does is it extends that so that when young people ages 18 to 21 want to purchase a gun, now it's able to, they're wanting to be able to look and see if there was a disqualifying offense from age 16 on. So they should be looking at juvenile records and receiving juvenile records on disqualifying offenses. So what's happening though, so it extends this background search from 3 days to 10 days in the event that the person looking to purchase the permit or firearm is between the ages of 18 and 21. That immediately extends to 10 days. And then it will go through either the FBI or the state point of contact, dependent on the state. But in addition, what the FBI is doing is manually reaching out to 3 points of contact within each state. A law enforcement contact, a state court contact, and another one that I forgot. A mental health contact. So I don't know, maybe some of you have been involved in some of those conversations at the state level about who the correct contacts are. I think there are some things that are still trying to be ironed out of that process. I know, for example, right now there's a automatic email that goes out that does not look in the FBI NICS system first. It they first do the manual reach out and then follow up with looking into the NICS system, and they're hoping to change that moving forward. So there's some kinks on that end that need to be worked out, but I wanted to note that they are actually manually reaching out to those 3 contacts that have been established in each state. And in some cases, this is additional 5,000 checks a week that are happening. So this has been a real big increase in workload for the FBI to do this. And then I mentioned, so there are there are FBI states. So the green states on this map are what are called non-POC states. So these states rely on the FBI to do all of their background searching for disqualifying offenses. Some of those states have a automatic data integration that occurs through their SAA or law enforcement, so that the NICS system is already aware of that. Others rely on kind of manual calling and emails. The red states are point of contact states. They are responsible for their own data on disqualifying offenses. And then we have a couple states that are like half and half, depending on the type of license or firearm. Why this is important for the conversation about the Bipartisan Safer Community Act, though, is because those point of contact states do have to, or those green states do have to think about what they're going to do with juvenile records and how they're going to make sure that juvenile records, the final disposition on juvenile records, are available to FBI, either through an automated process or a manual process. I'm going to turn it back over to Chris for the money talk.
Thanks, Terry. So the first of the 2 funding streams that I want to talk about is the burn SCIP, or the State Crisis Intervention Programs. And so I mentioned that the BSCA, we found out at our meeting with Search a couple weeks ago that the federal government has been calling it BISCA. We're not really used to that yet. But it created a new program area in the Burn JAG statute, again, which is really the federal overlay of priorities in criminal justice, called State Crisis Intervention Court Proceedings and Related Programs or Initiatives. So again, it's very rare for the federal government, for Congress, to be looking directly at state courts. And Congress gave examples. They said drug courts, mental health courts, veterans treatment courts, and extreme risk protection order programs. ERPO, or red flag programs. And that is, the red flag laws are definitely a strategy that at least the congressional supporters of the bill are looking to in terms of firearms restrictions. But they know full well that there are states in which that have had red flag laws for a long time. There are states in which they are not even on the horizon or on the radar. But there are some minimum requirements. I talked about closing the boyfriend loophole as one of them. And they're definitely emphasizing ERPO laws, but there are other uses for the funds. And significantly for courts, Congress expanded the scope of Burn JAG and Burn SCIP funds to include civil proceedings in addition to criminal proceedings. And I think in the context of the bill, personally, I think it's fairly obvious that they were referring to these red flag laws when they talked about expanding into civil proceedings. But again, this is an example of how the statute was sort of pushed through very, very quickly, and it's not clear from the letter of the statute that it is confined to ERPO laws. So the Burn Skip program is administered by the Bureau of Justice Assistance within the Department of Justice, and it provides $750 million over 5 years. And again, as I said, it started in 2022. So it's formula funding, and it's based on a very complex formula that is based on population and crime rates, and that is followed by the Burn JAG funding to reach the percentages. There's a base that everyone gets. As you can see, it's $644 plus $1,000. But the range, because it's based on population, goes all the way up to California's $29.2 million. And significantly, it's administered through the state criminal justice, what they call the state administering agencies, or SAAs. In your state, it may be called the Criminal Justice Planning Agency. There's lots of different titles, and sometimes it's the central agency in the executive branch that not only administers Burn JAG funds, but several other different federal funding streams in the criminal justice area. In addition, like Burn JAG, there's a pass-through requirement for local units of government of 40%, and the guidelines from BJA have indicated that part of that for percentage of the pass-through to local governments could be assigned to the state AOC, for example. And it requires a newly designated advisory board to plan and administer these funds particularly. And that's important for a couple of reasons. One is Burn JAG already has an advisory board. Could you use that board? Well, yes, you can use an existing advisory board, but it must meet the minimum requirements for Burn Skip, which includes representation from several categories of members, including courts. We've certainly encouraged state court administrators and chief justices to be invited to the advisory board and to be consulted on who would be the best representative. And so that's key to this funding, is having a voice on the advisory board to plan for the funds. And also, the thing to remember is applications will be made to the SAA, or the Criminal Justice State Administering Agencies. And so get to know your SAA is one of the messages. The applications were originally, the original deadline was December 19th of 2022, and the application that was necessary at that time was really a commitment to meet the requirements, because it was not much time, you can see, between October and December. So meet those commitments, to form the advisory board, to ensure that, create assurances that the state is going to meet the requirements. But they certainly didn't, it wasn't required to already have your total plan in place and already have your advisory board constituted. And it turned out that 7 states did not apply. And we found out fairly recently from BJA that about the 7 states, and They are indicated a willingness to work with courts and state agencies, hopefully together, to reopen the process, because they don't want to hold on to the money, and they want to expend the funds as Congress intended. So this Crisis Intervention Advisory Board, you can see that this is more than the Burn JAG board that already exists. This is really to create planning around reducing gun violence in the state. As I mentioned, mandatory members include members from the courts, behavioral health providers, attorneys, victim services. And I already mentioned that existing advisory boards could be used. There's an FAQ document that you can link to from the presentation. It's very, and it's updated as they go. And it's pretty extensive guidelines. So this is sort of the official guidance from the Bureau of Justice Assistance on these funds. And even though it's sort of in a sort of informal looking FAQ format, it's really their official position. So it's worth taking seriously and worth looking at. And that's part of where I got the funding that could be given to state court administration for distribution to local courts, especially if, as we hope, the plan is sort of court heavy, if you will, on uses for the funds. So, are there any questions about the burn skip funding before we go on? Mm-hmm. Mm-hmm.
Had a slide that showed treatment courts, drug courts, and a couple of protective orders. But it's unclear to me, is that just under the juvenile justice umbrella?
So the question was whether the burn skip funding umbrella was particularly focused on juvenile justice issues, and it's not. So we're actually going to get to that in the next section of the juvenile justice focused funding. But so this is more criminal justice oriented in general. And again, I think there's a lot of opportunity for plans in different states to go sort of in a variety of directions in terms of this funding, which is, by the way, $750 million over 5 years, $150 million a year, but because fiscal year 22 and fiscal year 23 are put together, there's over $250 million going out to the states for fiscal year 23, basically. So, we'll return to this theme at the end, but this is a good time for new applicants for funding, including courts, because frankly, there's an overlap with the existing Burn JAG program. A lot of the traditional recipients of Burn JAG funding, law enforcement, for example, already has access to a lot of funding. So I think we'll get to the juvenile justice area now with what the Bureau of Justice Statistics is calling the NCHIP supplemental program. And just as a backdrop, the federal law bans sales of firearms to a person under indictment of or convicted of a felony, including as a juvenile. That's how the statute reads. And bans sales to someone who has been, quote, adjudicated as a mental defective or has been committed to any mental institution. And we're going to talk about sort of the challenges that presents in defining the scope of the funding, and Terry's going to do that in a minute. The BSCA does add a provision that if you had a mental illness restriction that where the adjudication took place before you turned 16, that would not affect your ability to purchase a gun. That's a new provision. I mentioned administered by the Bureau of Justice Statistics. There's $200 million over 5 years. And again, fiscal year 22 and fiscal year 23 are put together. So it's $80 million in the first year nationwide. Unlike the burn skip funding, this is discretionary funding. So they are grant applications made directly to the Bureau of Justice Statistics. The solicitation was released in November, and here are the eligible applicants: state criminal justice agencies, federally recognized tribes, and state court systems. So when BJS was creating the terms for this funding, they said we don't want to deal with 100 different local court grant applications from local jurisdictions. We want one plan, and so it's defined as essentially, in a few more words than that, the administrative office of the courts, the state level administrative office of the courts, or its equivalent. And the application deadline is later this month. And you'll see, actually, almost every federal application has two deadlines. One is the deadline to register in their Just Grant system. Is that what it's called? Yeah, and then you make the formal application a week later in grants.gov. And they expect to announce awards in May. Here are the priorities for this year: improving access and reporting of adult and juvenile dispositions and mental health submissions to NICS, updating and automating criminal case outcomes, improving access to mental health dispositions, that's a real challenge, transmitting records to NICS, and efforts to seal and expunge criminal history information. So that could be, for instance, automating what in many jurisdictions is now a manual process, and supporting participation in the fingerprint files. And now I'm going to turn it over to Terry.
Thanks, Chris. So Chris just talked about a whole bunch of money that's out there, right? And so I think just to summarize, we have the burn skip money that can be used for court programming, crisis intervention. It does not have to be specific to juvenile justice, but it does have to be specific to crisis intervention. They include specialty courts as examples, but they are open to other ideas and other strategies. And then the CHIP supplemental is to improve reporting to NICS for juvenile and adults. There is a lot of money there, and we have not heard from any states that are going for it. So I really encourage you to talk to folks and see if your state's going for that. And we're going to talk about some specific examples of how that money can be used to support improving NICS reporting. But I will say NCSC is available to help. We are working on a template for states because it is a very fast turnaround if you are just now deciding to go for it. So we're happy to talk to you about the different ways that you could use that. But in our meeting at Search last week, the folks from the Department of Justice were very encouraging of state courts to apply. They will take, I think Chris mentioned, they will take 2 applications from a state, one from the SAA and one from the state court. So I just encourage you to consider thinking about that. So anyway, you might know what you want to do, but you might also not have an idea what to do. So I'm going to try to talk you through a couple a couple scenarios here on how to use that CHIP supplemental. First, I want to just kind of talk through what some of the language is in the Bipartisan Safer Communities Act. In our conversations with states, there have been a couple things that have been hang-ups as people have had to navigate and think through how that fits with their state statutes. So I just wanted to call some of them out for your attention. First is in terms of the language in the act talks about an individual under indictment who has been convicted of a crime punishable by imprisonment. And many states have statutes or juvenile codes that say that these words do not apply to young people, right? They say that juveniles are adjudicated, they're not convicted, that they're not in prison, that they're committed, that they're not an indictment. There's a petition to the juvenile court. And so some states have had some discussions or difficulty applying this federal legislation to their juvenile code. So that might be some conversation that you're having in your states. And we've heard from states on both sides. Some states have actual statutes that say juveniles shall not be referred to as imprisoned, right? So there are some, it depends entirely on how the statutes are written in your court, and other states are able to say, well, we understand the intent of this and can apply it. So that's probably the biggest hang up we've heard so far from states. Secondly, there is language about user of or addicted to any controlled substance. And this can go as far as to just admitting to using a controlled substance. So when we're talking about young people, this is something that can happen and not be part of a court record. But there are also many states that have similar language in their disqualifying offenses for firearms. So I would just encourage you to understand your state's disqualifying offenses and see how this applies or matches or aligns or does not. And then there is the section that Chris referred to when he was talking about the boyfriend loophole. And domestic violence with juveniles can be tricky because the way that this is written, if a young person, often domestic violence when you're talking about a juvenile is against a parent. And so the way that it's written here does not include against the parent. It's an intimate partner or the intimate partner's child. So this may or may not align with what your state statutes say. Sometimes when we have a family domestic incident with a young person, it's not considered under the misdemeanor of domestic violence, depending on what state you're in. So this piece, there are some questions that states will have to figure out for themselves how this applies to the way that they describe interfamiliar domestic violence. I just made up that word, but I meant parent and child. So those are kind of the language that we need to be careful about. And then, as I mentioned at the beginning, I've spent a lot of my words over the past 20 years of my life talking about the importance of keeping kids' records confidential. So one of the things that we need to emphasize is that the information that is shared with NICS is only used for firearm and permit purchasing. It's not going to be accessible for employment or for military, and that's a lot of the, or for housing. Those are a lot of the concerns that juvenile justice advocates will have, is who has this information once it's out there, especially when we get to the piece about mental health records, which I'll talk to in a second. So just making sure that many states, well, all states have language about the confidentiality or the extent of confidentiality of juvenile records, but most states allow for that sharing of information with law enforcement, which is what NICS would be considered. And then one kind of thing to keep in mind is that when young people's cases are expunged or sealed, or if they receive, they get their gun or firearm rights restored, that is the requirement of the state to change that in the NICS system. So the FBI does not keep up with that kind of information. So if you are in a state who is automatically transferring this information to NICS, it is also your responsibility then, if that case is expunged, sealed, or their rights are restored, to go and change that. And so I just wanted to throw in here, because we've had a lot of questions about confidentiality and records confidentiality and how this act interacts with confidentiality. The Juvenile Law Center, now this is about 10 years old now, but I still think that it is a great source of information, and it's actually linked on the slide in your app. But they have gone through and scored every state statute in terms of how it aligns with kind of what they consider to be best practices in juvenile confidentiality. And so I just think that's a really good resource in terms of understanding what your state statutes are and how that might interact with the extent to which you can share records with NICS. So again, that link is in the slide, and you can check that out in your in the app. But that's mostly about. Oh, yes, sir.
Get you to red, I guess.
Yeah. So it's on a scale from like 100 to 0. So green is what the Juvenile Law Center considers to be good policies on confidentiality of records. Now, this was 10 years ago, so it doesn't have anything to do with NICS, but it has to do with are kids, are the hearings open or closed, are records inaccessible to people outside the court, are they publicly available, can people request them, that kind of stuff. Thank you. Any other questions or comments? So this map, and most of the time when we talk about confidentiality of juvenile records, we're talking about court records, right? In the Bipartisan Safer Community Act, they talk about mental health records. And I think there's been a lot of questions and conversation about what that means for young people. So the language in the act has been adjudicated as a mental defective or has been committed to any mental institution at age 16 years or older. I don't know of a single state that has a young person adjudicated as a mental defective. I don't know that that language exists in the juvenile world. And so it brings up a lot of questions about what this means. In the adult world, it means that there is some kind of involuntary commitment. In the kid world, there can be, is it considered involuntary if a parent commits a young person to a mental health institution? In some states, it can be. So there are some state-by-state decisions about what a mental health record is. And we did learn at Search that some states this information is getting retrieved from Health and Human Services or the Behavioral Health State Department, not from court records of adjudication. So it's not right now done consistently across all states. And then the other question is too, sometimes if a young person is committed to a mental institution, that's done in our dependency system, not in our delinquency system, right? It might be done under in the juvenile court, but in a different code. And so it's not clear yet if those young people are also subject to this or not. And so it goes on to say has been found by a court, blah, 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 about the individual has been found incompetent to stand trial or not guilty due to mental incapacity. And we have been doing a lot of work on juvenile competency statutes and what that means and how they're different than adult competency. Many states still apply the adult competency statute to young people, but there are a number of states who have a juvenile competency statute that takes into consideration developmental delays, developmental age of young people. And also the restoration which is hard to restore a young person because they're not competent, they probably haven't been before either. But the restoration for juvenile competency is a bit different than it is. It's a lot different than it is for adults. So this, and right now, there is no way for us to even know how many kids across the country are found to be incompetent to stand trial or proceed. There's no way to collect that data. Some states use that often because they have good services to support those young people to get the help that they need, if that's found. Other states rarely, if ever, use this because they don't have those systems. So figuring out how this applies best in your state, in the way that you look at juvenile competency and support restoration, I think is really important. And then we get down to has been involuntarily hospitalized or committed, even for substance abuse, by court, board, commissioner, lawful authority. We have had some conversations with folks about whether this means placement in an RTF, for example, whether this means placement in some kind of mental health or substance use treatment center. And I think that that is largely left up to the states to decide what that means for them. But I would just encourage you, because this area can be fuzzy, to really have those conversations with your behavioral health folks, with your juvenile court folks, and have a shared consensus about what this means for your state, so that when you are getting the phone calls from the FBI, if a young person is asking to purchase a firearm between the ages of 18 and 21, and if they were placed in an RTF because that was the placement that was available to them, does that count in your state? So I think that there are some nuances here that have to be worked out as to mental health records.
I have to say, the first time I saw the language adjudicated as a mental defective, I was taken aback, because I don't think I've ever hardly seen language like that in any statute.
The legacy of the way they describe mental health issues, especially for children, I think it was in our Maryland statute up until recently.
It's interesting. And I know a lot of advocacy organizations that have reached out to us are very concerned about the use of, just mental health records being broader than court-ordered mental health treatment. And so especially with the amount of funding coming down through school mental health, just being very clear in your state what mental health records for the purposes of the Bipartisan Safer Community Act mean.
So when Terry and I and other colleagues were sort of batting around, what does this mean? And the involuntarily hospitalized, I practiced in a state in California where there was a whole, body of statutory and case law around that used the involuntary commitment statutes for children. But then, there are other states in which all of that comes under the child welfare laws, for example. So it really creates some confusion from state to state.
Mm-hmm. And in some states, a parent can involuntarily hospitalize a young person. And other times they need it. In other states, they need to have a court order to do that. But the parent can get that court order. Yeah. So this is kind of tricky. Sorry, I don't have better answers about that. But that is, I think, conversations to have within your state about what that means. So some of the technology challenges when we talk about adding the juvenile records, court records, and mental health records to whatever your state's process is for sharing information with NICS, is thinking about where does the information live? So where does the offense information for young people live? In some states, that might not be in the state wide data system. It might be in a county or district data system. So for those disqualifying offenses, they're looking for the final disposition of those. In some places, they don't have a ID that can carry over both from juvenile to adult. So when a young person is an adult, they'll need to be able to look and see if they had juvenile records. So that can be tricky some places. Who has access to the information? The people who are communicating with NICS vary widely depending on what state you're in and what decisions they've made. So just encourage you to be knowledgeable about that, and again, make sure that there's a consensus as to what records are allowed to be shared. I do know there are a couple states who have decided that they are unable to, based on their statute, share records, juvenile records with NICS, and they all have, the two states I'm thinking of, have a auto response that goes to the FBI when they get the email that says, under our statutes, we're not allowed to share that information. But we've also heard of examples of states that had that agreement but didn't share that information with their local courts. And so then the FBI reached out to the local courts and got the information. So I just encourage you to talk about it as a state and make sure that that information is trickling down to your local courts as well. Can there be an integration? Can we get this not to be a manualized process? Right now, as I mentioned, FBI is calling states manually, 3 calls for every request. If we can manually get an integration, that takes workload off of the courts and the FBI. And we'll talk a little bit about how this money can be used for that. And then, again, sealing and expunging records. If there is a record that would be a disqualifying offense that went to NICS and it is sealed or expunged, again, that's on the states to fix that in the NICS system. So again, that's a workload issue for state courts. So is there a way to automate that process so that it can take some of that work off of your hands? So those are some of the key technology challenges that we've heard about when we talk to states about implementing this. But luckily, there are lots of opportunities. So Chris mentioned a lot of money. And again, I'll do a plug. Please apply. Ask us if you need help. There's money, and they are willing to give it to you. Some of the ways that that money can be used, this is specifically the CHIP supplemental I'm talking about here. You have to connect it to improving reporting to NICS. And there are a number of things you can do to improve reporting to NICS. First, you can improve your data systems. So I know of states that are going to apply to get brand new data systems. So if you are in a state, and it doesn't just have to be for juvenile, it can be for everybody. But if you are in a state that's looking for ways to improve, enhance your current data system or get a whole new one, this can be money that can help support that. So any improvement to your data systems. There are a number of states looking at automating record sealing and expungement. Even if you do that within your own court data system, if we can figure out a way to integrate that with NICS, or at least have it happen automatically, so when NICS calls to check on these people, if that has been expunged, that record is not accessible. That would be wonderful for those young people. And then increasing data quality. When I was at Search, I heard a lot about poor data quality from the courts. And I stood up for you all. No. And they said number one thing that they need is final disposition. They have a really, really hard time finding final disposition. So if there can be, this money can be used to do data cleaning. There were states talking about hiring temps to come in and do data quality checks, to take paper files and type it into computers, to do data entry. This money can be used for something like that too. And so I'd encourage you, if you have a box of files that you need to enter, or if you have data, or if you know your data quality hasn't been checked in a while or could be cleaned up, this is a great use of that money. Fourth, and this isn't even really about data, but stakeholder meetings. If a lot of this talk about improving the NICS and improving the data that FBI has available for firearms comes down to people talking to each other and understanding what data is available to you and what's the best way to get it to the people that need it. So this money can also be used to have stakeholder meetings with your SAAs, your criminal repositories, with courts, with law enforcement, and talk about how you're collecting data, how it could be done better, what kind of challenges or issues you're experiencing. Chris and I both left the Search meeting thinking, wow, if we could just get state court administrators in a room with these Search people, I think that there would be a lot of positive impact. This money can be used to do some of that gathering and communication and talking about improving data. Providing guidance to local courts. I gave the example of a local court not knowing what the state court stance was. So just making sure that there is a consensus about how and what you're sharing will be really helpful. And this money can be used to help support that. And then finally, partnership with data system vendors and standardization. I would be a bad NCSC staff person if I didn't mention NODS, which is our research team has been working on NODS, all about data standardization across case types. And this is a perfect opportunity to implement that NODS, which means being able to standardize your data, especially if you have several different data systems that are trying to talk to each other. But this data standardization can take a lot of time and energy, and this money can be used to improve that. So those are just a couple of the examples that we've heard of or thought of ways to use this money that would directly improve reporting to NICS. So, I don't know. Chris, did you want to add any other ones?
Sure. Well, actually, I wanted to add one that a specific example that BJA has offered in the Burn Skip funding Again, it's necessary for it to be conformed to a state plan and be approved ultimately by the state advisory board. So that's why we're really hoping to get court representation in there. But you'll recall that Congress specified problem-solving courts, in particular drug courts, mental health courts, and veterans courts, as possible programs to fund with that money. And there's long been a prohibition. As you know, there are other sources of funding, dedicated sources of funding for those problem-solving courts. But there's always been an exemption for violent offenders, which, cuts out potentially a lot of folks that could benefit from those programs. This funding does not have that restriction. So BJA, the federal government itself, has suggested that that's one area where you might expand, say, a drug court program to include specialized programs for violent offenders. And just to piggyback on what sort of the theme, I think, that, when you have new money that has a lot of vagaries around the edges, and courts kind of written into the thoughts of programs, this is a good time to apply for funding. Yes, it's going to be there next year, but there's more money this year, and there's a lot that is still to be defined. And, from my point of view, it would not be a great look for them to offer money to the courts that doesn't get spent when we go back to Congress and try to get more resources for the state courts. And I think the message that we got, without certainly any promises, is that, like in this NCHIP supplemental funding, that a proposal that is within the scope, arguably within the scope, is likely to get funded because, they have more money than they have applications.
Absolutely. So and we're, again, working on a template to help make that easier for all of you, and would be happy to help with that because it is a quick turnaround. I want to add too, if you have rural jurisdictions, because treatment courts were the examples they gave, but those can be resource intensive, and sometimes rural jurisdictions don't have the bandwidth to be able to support an entire treatment court. But there are practices from treatment courts, like case coordination, screening, that can be applied in rural jurisdictions too. And those would also be an appropriate use of the SCIP money. So even if you can't support an entire program, there are practices. And I'll do a plug for my 2:00 session on family-centered justice if you want to hear about those practices.
And one other tie-in that comes to mind, some of you may know that the National Judicial Mental Health Task Force of the Conference of Chief Justices and Conference of State Court Administrators has been meeting for years, and they released their final report late last year, certainly encouraging states and local jurisdictions to convene coalitions on mental health issues, and just remembering that there's a whole lot of new mental health funding in the Bipartisan Safer Communities Act. And so, putting together a plan that could tap into sort of multiple sources of funding to implement mental health services as part of a firearms reduction plan it certainly has some promise. Any questions? Well, thank you very much. Thanks for coming.